Hello everyone, very warm welcome once again to your favorite channel, that is Study IQ IS English. My name is Praveen Mishra and we are going to discuss a very serious topic for the day. As you are watching an image here, a woman in distress. Well, women in distress in India is not new thing, just not India. Women in distress globally is not a new thing to us. But there is something strange. That is what we are experiencing as with regard to the judgment or the statement that has come from the Allahabad High Court judge with regard to an attempt to rape towards a minor girl. And one such thing has once again roared up, or it's floating once again over the internet, as well as it is also troubling the masses, the mindsets of the liberals, as well as not only just the liberals, but the whole of us. That is, here is the news, first of all. Women can't be forced to undergo a virginity test as it violates Article 21, has to state Chhattisgarh High Court. Let me tell you the whole news. A married couple in Chhattisgarh, the husband has actually accused his wife that the wife is having some illicit relations with maybe some other people as well, and because of which I believe there is some concern over the, what we can call it as the physical relations we do possess, and apart from that something other as well, which talks about morality as well as the loyalty factor and so on. That's correct. But from out of nowhere, a concern raised out that let's have a virginity test. The word virginity test itself is pathetic, is the biggest pathetic thing in the civilized human society. If it does exist, it is as of now, right? The most pathetic thing, the most nonsense, illogical thing is what? This one word, virginity test. First thing that needs to be understood here, there shouldn't be anything that is known as virginity test. But though it is floating, since the ages, and the people, specifically those who consider themselves as more manly or more masculine or something like that, they do prefer such type of things. See, I'm not denying being masculine or having that, manly attitude. Okay, that's fine enough. But it should be in some sphere. That is when it comes to providing protection, when it comes to providing safeguard to your community, to your family, to your society, to your nation as a whole, there should be the concept of masculinity. And this concept of masculinity doesn't only center to males, but it is also on the very parallel side is also centered to the females as well. But the concept of patriarchy and masculinity is often misunderstood, and apart from that, it is also infected with some, vicious mindsets or the poisonous mindsets, apart from that with some hostile intentions of having the dominance over the society. That is the outcome here, virginity test. Okay, so this is what High Court of Chhattisgarh, some wonderful thing that must be applauded here. Okay, established that Article 21 is the heart of the fundamental rights, and the High Court said granting permission for a virginity test would be against the fundamental rights, cardinal principles of natural justice and secret modesty of a female. This is what Article 39 also has to state, that you should be taking care of the modesty and dignity of the women. This is what Article 51 capital A, fundamental duties, has to state as well, that is safeguarding the modesty and dignity of the women. And asking such pathetic things, firstly it represents your ill mind, and secondly it also represents that how much back orthodox or stereotype still you are even in the 21st century. Right? So coming to the whole scenario, that no, there should be nothing known as the virginity test. One of the champions of these things, that is Justice Arvind Kumar Verma of the Honorable Chhattisgarh High Court, made this observation in response to a criminal petition. See the word here, criminal petition filed by a man who demanded his wife's virginity test alleging she was in an illicit relationship with another man, challenging a family court's order dated October 15, 2024, which rejected the interim application. The subordinate court rejected, but that guy went to the high court as well. नहीं नहीं, अपने को तो virginity test चाहिए भाई, जाओ ले लो, ठीक है, दे दिया आंसर ऑनरेबल कोर्ट ने. Now go take it. This is what high court has to state, right? You want virginity test? Come here, right? So this is what the principles of natural justice comes into the picture, and apart from that, the heart of the fundamental rights of our country, that is Article 21, right to life and personal liberty. This was even also marked in the year 2019 when the Honorable Supreme Court of India decriminalized section 497 of the Indian Penal Code, the erstwhile Indian Penal Code, that is the IPC. Section 497, which was simply talking about adultery. Adultery as in when a man is having an affair with another married woman. That particular relationship was considered adultery, and adultery was given the tag of a criminal offense inside the state of our country, that is India, till 2019. But the fact is, adultery was absolutely declared in means not so criminal offense, or it was decriminalized by the Honorable Supreme Court of India in the year 2019 itself, and section 497 was said to be not in use anymore. So even if adultery was a criminal offense till date, even if in case, then also this demand of a virginity test by a husband against his wife was standing on absolutely mala fide grounds. Okay, it was nowhere bona fide. So what does Article 21 of the Indian Constitution has to come in? So here we go. It talks about the life, protection of life and personal liberty. This is also what we are going to discuss in our fundamental rights classes, that is about to be live in quite some time. Okay, so no person shall be deprived of his life and personal liberty except according to the procedure established by law. This is something, okay, that is mentioned in our Article 21 in the Indian Constitution. The fundamental rights is available to every person, citizens and foreigners as well, and it provides two different rights. The first one is right to life and the other one is right to personal liberty. So the fact is that we need to understand right to life, though just 3 lines, right to life, but the definition varies person to person. What's the definition of life for me could not be for you. What's the definition of life for you could not be for me. Right? For you, the life could be, okay, every weekend I want party. For me, life would be, okay, every weekend I want to go on a mountain trip. For me, life could be, okay, I need a cup of coffee anyhow to start my day. For you, it could be a cup of tea or maybe some other beverage or maybe not even a beverage. For me, life could be, okay, that I want to, eat this and that every day in order to my body, to let my body function or perform at its best. For you, it not be any meal or type of sort of a meal. Okay, it could be any meal for you. So the definition of life depends from person to person. It is having the biggest definition in our constitution, though mentioned in just 3 lines. And apart from that, that comes into the picture here is, that is personal liberty. Personal liberty and life, they do also provide us the right to privacy. Okay, so what we need to discuss here is right to privacy. Is it an intrinsic part of life and liberty? Yes. This is what the Honorable Supreme Court also has to state, that right to privacy, and make no mistake here, talking about virginity test is a grave violation and infringement of the thing that is known as right to privacy. Okay. So, right to privacy is an intrinsic to life and personal liberty and is inherently protected under Article 21 of the Indian Constitution as stated by the judiciary, the apex court, in K.S. Puttaswamy case of 2017. Okay, so guys, please mark out the case reference, that is K.S. Puttaswamy case, in which the 9-judge bench unanimously reaffirmed that the right to privacy is a fundamental right under Article 21. And apart from that, there are some other cases in which the right to privacy was neglected as a fundamental right. Okay, so Supreme Court actually overruled. Okay, overruled the judgments in the cases of MP Sharma and Khadak Singh cases. Okay, where the right to privacy was not integrated with Article 21. But in KS Puttaswamy case, KS Puttaswamy versus Union of India case, it was clearly stated that yes, right to privacy is an intrinsic part of our Article 21. Okay, so here we go, guys, with regard to the cases. Okay, sorry, not the cases, MCQs with regard to the topic that we have discussed, that is right to privacy is recognized as a fundamental right under the Constitution of India in which of the following cases. So it should be as simple as that, as we just discussed a minute back or some seconds back. That is option C, KS Puttaswamy versus Union of India case. So as you can see, okay, it happened in the year 2017, and in this case, Supreme Court unanimously, that is without any opposition by other judges, declared that the right to privacy is a fundamental right protected under the Constitution of India. Next question, which of the following is not, please highlight the word not, a condition under which the right to privacy can be restricted as per the Supreme Court's judgment in the Puttaswamy case. So not a condition. If you are watching the classes of Indian polity regularly, so you would be aware about a doctrine, that is doctrine of reasonable restrictions. So doctrine of reasonable restrictions that has been inducted by the judiciary as well as the parliamentary actions a multiple of the times since the inception of the Constitution. And here is also the usage of the doctrine of reasonable restrictions, that is not a condition for right to privacy, okay, for its infringement actually. So is it by law? Is it for the sake of the interest of the national security? Is it for the prevention of crime? Or is it for any reason deemed appropriate by the government? So what do you think could be the correct answer? Okay, so yes, the correct answer is D. It's not the reason, because it is something which is representing the arbitrary action of the government. So for any reason deemed appropriate by the government, no. The right to privacy can only be put under restriction bar, that is by law, okay, or for any criminal investigation, that is for the sake of DNA testing and so on. And apart from that, the third thing, that is for the sake of the interest of national security or the law and order situation. Next, which of the following provisions of the IPC is most likely to be invoked in the cases of violation of the right to privacy? So this is also what we have discussed in our daily current affairs classes, the analysis classes. If you are watching it live, then for sure live or whatever, then for sure you have the answer. So IPC is invoked for the case of violation of privacy. So yes, it is. Yes, what is the correct answer? Section 66E, punishment for violation of privacy when it comes to the Information Technology Act. Okay, it's not 376, it's not 498A, it's not 354, it is section 66 capital E, that is punishment for the violation of privacy. Okay, according to the Information Technology Act. Okay guys, so that's it from my side in this session. Thank you so much for watching, and if you wish to connect with me over my social media handles, so here are they. That is Instagram, Praveen Mishra _2107. You can just search for it and you can connect with me there. And apart from that, if you wish to connect with me over my Telegram channel, so it will be study_with_Praveen. So wherever you are comfortable, you can connect with me and share all of your doubts related to your academics or your UPSC CSE preparation and so on. Okay guys, so thank you so much for watching. Please do hit the like button if you do, and apart from that, please do not forget to subscribe the channel as well. Bye bye, take care, see you soon. Jai Hind, Jai Bharat.